Well, thank you very much, ladies and gentlemen, members, for joining this members briefing call. The topic of the call today is MiFID 3, or is it simply 2.5? So thank you very much for giving up an hour of your time today. I'm joined today, I'm delighted to say, by Elisa Monado, who is the Director of Policy and Public Affairs at Credit Suisse. And more importantly, from my perspective, she is also Chair of AFME's MiFID Steering Committee. My colleague Pedro Pinto, Director of Advocacy for AFME, joins me as well in the room, and I am Julian Alanos, Director of MiFID here at AFME. So I thought I'd start with a few housekeeping points. Well, we've got an hour in your diary today. I'll make some short introductory remarks, and then Elisa will kindly talk us through the MiFID review, which is currently live. Followed by Pedro, who's going to talk us through what lies ahead and forward-looking next steps with this important file. We'll leave some time for Q&A at the end of the discussion, and questions are to be submitted online via the web system. So where are we now? Well, MiFID 2 entered into force in January 2018, and it's one of the cornerstones of EU financial services law, and it sets out which investment services and activities should be licensed across the EU, and the organisational and conduct standards that those providing such services should comply with. And AFME supports the MiFID 2 review process being driven by fact-based analysis of the effects of the MiFID 2 regime in advance of any amendments being made. And our overall assessment is that MiFID 2 has been costly to implement for all segments of the financial sector, and it remains so on an ongoing basis. AFME also shares the overarching objective of the Commission's review of MiFID 2, specifically to improve market transparency and enhance investor protection. However, we believe that many of the provisions of the regime need recalibration in order to avoid damage to markets, liquidity, and investor choice. And by engaging with the Commission and the European Parliament, the Council, and ESMA, various member state national competent authorities, and all other official sector and non-official sector interlocutors, AFME is seeking to actively contribute to the MiFID 2 review. And the future of the EU capital markets is highly dependent on the advancement of the Capital Markets Union project. And as the primary rulebook for EU financial markets, the MiFID 2 framework is central to advancing CMU objectives to strengthen the capacity of EU capital markets, to reduce fragmentation, improve efficiency, and increase investor choice. We welcome that the Commission recently launched studies focused on the functioning of primary and secondary equity markets and the feasibility for the creation of the CMU Equity Market Index family. We look forward to engaging with these studies and the consultations open and with all interlocutors as they feed into this important MiFID review. Those of you who've been paying attention will notice that there are many consultation papers open at the moment. There's an ESMA CP on equity transparency due 17th of March. There's an ESMA CP on non-equity issues and SI functioning on the 18th of March. There is the Commission consultation paper on crypto topics, including MiFID, on the 19th of March deadline. So we really are backed up against on the wall in terms of deadlines and consultation papers. Further to those, there's the ESMA CP on third country firms and investment services with a deadline of the 31st of March. And finally, certainly not least, there's the Commission consultation paper on the review of the whole MiFID framework, which is open now and has a 20th of April deadline. So that keeps us busy up to and including Easter. How can members keep abreast of the issues and get involved in shaping MiFID 2.5 or MiFID 3 as we may refer to it? Please come and engage with the AFME forums on MiFID. There are legion of them. The central place for all MiFID coordination is in the AFME MiFID Steering Committee, and we would certainly be delighted for members to get further engaged on this important file. Mentioning the AFME MiFID Steering Committee leads me to ask the Chair, Elisa, can you give us a picture of what is going on now with MiFID? It seems not so long ago, January 2018, that it simply came into effect.
Yeah, it isn't not so long ago. The problem with the European legislation is that it was finalized in 2014, and I think we started working on that well before 2010. So it's actually 10 years old in some areas. So it's not surprising that the legislator, when MiFID was finalized, inserted a requirement that parts of it should be reviewed. The original timing for the review that the legislator had put in the original text was earlier than now, but as implementation of MiFID was delayed, so is the statutory review. So what's going on now? Well, we have the statutory review, which will take a while and will cover numerous subjects. And then we have a review that is not statutory, but is dictated by what's happened in the world recently. I can't get through anything these days without mentioning Brexit, but Brexit is relevant because securities regulation designed for an EU 28 union doesn't necessarily work as well for an EU 27 union. So that's one of the angles. And also the world has evolved since 2014. There's a number of ways of trading securities that just didn't exist then. And so quite rightly, the authorities are taking the opportunity to rethink. How much of a rethink it is, who knows? At the moment, we all think that it's a recalibration, I think is the polite way of putting it, and it's a tweaking here and there of the things that obviously don't work. But who knows whether it will stay like that or whether it will snowball into MiFID III. I don't have a crystal ball. So what do we have? Well, you've given an overview to listeners, but let's go back. Statutory review. So statutory review, those of you on the phone who've been following this for a while will remember that some time ago we've seen a letter from ESMA to the European Commission saying essentially, we know we need to report to you on a number of issues. The timelines that we were expecting to report to you on no longer work, so we will be reporting later. And the letter has a nice long table that gives each of the subjects on which ESMA is due to review and what later means. And later essentially means that sometime between 2019 and 2021, depending on what you're working on. The first one of those reports came out in December and covered the consolidated tape, which was mandated in legislation but doesn't exist yet. So ESMA makes some recommendations as to how an equity consolidated tape might work. And it also talks about market data, which is covered in the legislation, but where many players, including members of AFME, think that the legislation is not working properly because the sale of data to brokers should be on a reasonable commercial basis, and I still haven't found anyone who thinks that's what's happening at the moment. So you could say that those are two aspects of MiFID which are not working, but there's plenty of others that are. Two aspects that we're looking at now, as you were saying, are the ESMA consultations that are open at the moment that look at market microstructure. There's one on equities and there's one on fixed income. The relevant working groups are looking at them, and the work that is being done there is very detailed because we are talking to ESMA. ESMA is asking of market players very detailed technical questions, and we're giving them very detailed technical answers. Some of the same topics that are covered in those consultations are also covered in the European Commission consultation, which you also mentioned. That's different because that's it's much higher level, much more strategic questions, reflected in the fact that, as we all know, the European Commission is, or broadly speaking, the civil service of the European Union, and it is looking at what changes would be needed in the level 1 and the more political aspects of the level 2. While ESMA is advising the Commission on some of those changes, but is mostly focused on the technical aspects of level 2. And the themes that are covered in those three consultations, without descending into the detail, are things such as, should we have trading obligations? Most of the focus is on the share trading obligation and how it would work when the consolidated tape comes in. There is also the question, staying with equities, as to whether the double volume caps that limit dark trading should remain as they are, they should change, should there be multiple caps or should there be a single overall cap? What level should it be set at, or perhaps should it be scrapped altogether? The other things that we have that relate to the structural markets, looking more at fixed income, for example, but no doubt it will have a repercussion in equities as well, is there's a reopening of the concept of what's a multilateral system. Now, officially, the consultation is about multilateral systems, but if you discuss what's multilateral necessarily, you also consider where multilaterality stops and where bilaterality begins. And whenever you mention bilateral trading, you bring in systematic internalizers, which is also a subject that is covered both by ESMA in both consultations and by the European Commission. The Commission asked the very open question about, is it right that systematic internalizers are treated the way they are by the legislation? Should the is the playing field level, or should it be leveled? And I am sure that our response would be a more detailed version of the playing field as it is now more or less works, because it reflects the fact that the systematic internalizer and a trading venue are not doing the same thing. Systematic internalizer trades bilaterally with clients using its own capital and therefore providing liquidity, while a trading venue, as the name suggests, provides a place in which different buying and selling interests can meet, but there's no investment of capital into the trading. Of course, there's investment in infrastructure, but there is that for the SI as well. I suspect that's what we will argue on that. Other aspects that are addressed in the consultations include also commodity markets. However, that's not something that we're going to cover today, as only a small selection of AFME members follow that. And in the European Commission consultation, there's a large section on investor protection, raising some fairly fundamental questions. For example, we are asked to comment on whether the information that is currently mandated for clients is set at the appropriate level, whether it is right that professional clients should mandatorily receive the same level of costs information as retail clients, whether any type of client should be able to opt out of receiving that information, or only some types, and in which circumstances. We are also asked whether the existing client classification is right, or whether there's an argument for creating a new category of expert retail client. And if that's appropriate, what shape should that category have? How should it interact with the pre-existing categories? And how the requirements should be adapted for it. Now, the interesting question there is that MiFID doesn't exist in a vacuum, although it does feel like it's the entire life of the MiFID steering committee and those of us who spend most of our working days in it. So, for example, just taking client classification, designing a new client category or a new subset of a client category within MiFID needs to think how it would impact all of the other rules that also ride on the MiFID client classification, and how it would interact with new types of client that are being discussed in other regulations, such as the crowdfunding regulation and the proposals made in one of the CMU papers to have an easier way of investing for high net worth individuals. How do you find them? Where do those types of clients fall into the MiFID framework are some of the questions that we'll need to address in the coming days. So talking about other aspects that don't have MiFID in the label but still affect us, I've just mentioned the CMU, Capital Markets Union, for those who don't deal with it very often. Capital Markets Union has been around for a while, but hasn't quite worked, so it's being relaunched as an initiative, and the intention is to increase growth and to attract investment, and also to energize the retail savers in Europe to become retail investors, because there's a very large pool of money that is currently sitting in bank accounts, which it is thought would be better invested into the European economy via capital markets. How does that affect MiFID? Well, as Julian was saying earlier, securities regulation determines the rules that affect how investors can invest their money, how they can sell interests to one another, and how they receive advice. So MiFID is fundamental to the CMU, and there are aspects of the political proposals that will be made under the CMU that will require changes to MiFID. There are also the changes that I hinted at earlier that come about because of the changing shape of Europe. And so the investment firm review and the investment firm directive last year changed the MiFID equivalence framework and the rules that third country firms will be working under if they provide services into the European Union. So another consultation that is currently open and we're working on at the moment is the one on the type of information that third country firms wishing to provide services into Europe under MiFID 46 and 47 need to provide to ESMA. That sounds technical and boring. It is technical, but it's absolutely not boring. It's quite strategic because if the information required is extensive and intrusive and takes a very long time to put together, it brings into question the levels of cooperation amongst the regulators who are supervising the firms, and it also makes life difficult and complicated for those firms. So we are spending quite a lot of time on what might look a technical question, but it's actually a very strategic one. And then, as you were saying, there's the crypto asset consultation, because to the point that we made earlier that MiFID was finalized in 2014, I don't think crypto assets existed in 2014. They were certainly not as commonly discussed as they are now. And now we're being asked questions such as, if you have a security token that embeds a share, do you treat the share differently under MiFID than you would if it weren't embedded in a security token? And then if you don't, and the same rules apply, how does the transaction reporting work if the transaction in the security token hasn't taken place on the normal infrastructure that under MiFID would, for example, report transaction to regulators? What does it mean to safeguard a security token? We all know what it means to safeguard a share. We knew that when they were paper certificates. We know it now that there are entries in a ledger, but what does it mean when that ledger becomes a distributed one? Those are all the questions that we need to address, and that's something that we're doing with the specialists in crypto assets in the technology group.
Technology task force, yeah.
The technology task force. And then we have things that are not consultations, but also very much affect the outcome of the work that the Commission will do after the consultations, and are the market and feasibility studies that you referred to earlier. There's a major one on the structure of equity markets that is expected in June, and on which members had some input last year, that will no doubt inform the proposal that the European Commission designed. There's also more detailed and very technical feasibility and impact study on the consolidated tape that is underway as we speak. And there was last year a study on the impact of the research and bundling rules, which is one of the issues that the Commission is also addressing in its consultation.
Thank you, Lisa. That's a very comprehensive list of some of the topics that are being discussed in the CPs. Sometimes we're accused of generating laundry lists of issues, but I think in this case, with 1.4 million paragraphs of legal text, a laundry list is a necessary output. Could you help us understand what are the key themes under discussion, please?
Yes, they are the things that we've been discussing in various forms over the last 4 or 5 years. So as I was saying earlier, trading obligations. Well, we all know there's a lot of problems with the share trading obligation. What should it look like if it continues to exist? And I say if it continues to exist because one of the questions that are being asked is whether it should indeed continue to exist. As I was saying earlier, if the share trading obligation continues to exist and there is then a consolidated tape, how are the two going to relate to each other? And do you still need the double volume caps? What should they look like? These are all of the sort of things on which people agree. Something that we haven't mentioned yet is that there is now general agreement, we think, amongst policymakers that giving a large wholesale client the same information that is given to you and me when we make our own personal investments is not appropriate to the needs of that client, and that sort of client should be allowed to negotiate with its service providers as to the format and frequency of cost information that it receives. There is also, as we were saying earlier, general agreement that a consolidated tape, as is designed now, doesn't work, so something needs to be done about that, and that it's probably time to reduce the national discretions that are currently available and built into MiFID, frankly, that were built into MiFID to allow MiFID 2 to come out in some form. But there's also a lot of things on which people disagree. So to take the share trading obligation, everybody agrees as it is now doesn't work, but some people think that the scope of the new trading obligation should be determined by whether a company is established in Europe or not, i.e. whether it has its legal seat in Europe, which would give it a Europeanizing. Others say that no, perhaps the scope should be determined in another way, or that you should use an ISIN, but also just look at European ISINs that are traded in European currencies. On the consolidated tape, there's some people who say, yes, consolidated tape would be a good thing, but let's start with a post-trade consolidated tape of record, and let's think later on about pre-trade. Others who tell you that the only way to make this work is to have a real-time, live, pre- and post-trade tape, and that you should do equity and fixed income at the same time. In terms of the semi-professional client category that I mentioned earlier, there's some people who say that it's fundamental to allow further investment by expert retail investors that are currently being stopped from having access to investments that are perfectly suitable for them. And there are others who say that while that might be true, it's better to maintain the level of protection high, and that what we have is appropriate. There's also some who are pushing to remove the rules on telephone taping, so who don't want orders to have to be received on tape lines. And then there are others who are perfectly happy with that, because if it's compulsory, it has to happen, and then it's easy to prove who ordered what when, if there's a dispute. But as we were hinting at in the discussion, there are also some recurring themes on which people disagree, but we're talking about them all the time. And so, for example, we all agree that retail participation is too low, and that the costs of investing are too high, and that the information received is by retail investors is sometimes complex. What people disagree about is what to do about it. There's also a lot of discussion about, as I was saying earlier, about the right balance between the obligations and rights of systematic internalizers and trading venues. There's much talk by regulators as to whether it is right to try to have the current amount of trading on lit venues, and whether more trading should happen on them as opposed to in the dark. Which is something that we're discussing with them. There's also a question as to whether the proportion of trading that is not price forming is right, and whether that should be a concern, whether that should change. And the other thing that we've been working on a little bit is whether there should be open access to post-trade infrastructure, as was mandated by MiFID 2, but which some actors would like to stop.
Thank you very much, Elisa. That is a very comprehensive review of some of the granular issues in the CP and some of the general themes, key themes and recurring themes. So I found that very useful, and I hope members on the call did too. I'm going to turn to Pedro now, my esteemed colleague from Brussels, and ask him what next? What steps are necessary towards the conclusion of the review of MiFID? The EU Commission reports to the EU Parliament and to the Council, and how will the process be taken forward? And critically, how is AFME going to be involved?
Thank you, Julian. Indeed, as Elisa just said, and you started by outlining that there's a few initiatives outstanding, and maybe in the interest of members, I will focus specifically on the initiative potentially with immediate impact on members. That's the European Commission consultation paper on the review of MiFID. And indeed, looking ahead, we can see a few milestones down the road and involving different institutions. If I start maybe with the European Commission, and before that, maybe a brief explanation from the outset in relation to the Commission initiative, though. Members would recall that further to the so-called Better Regulation Initiative agreed during the Commission previous mandate, a so-called REFIT program in relation to EU legislation was put in place. REFIT stands, for those who don't know, for Regulatory Fitness and Performance Program. This REFIT program aims to ensure that EU legislation delivers results for citizens and businesses effectively, efficiently, and at a minimum cost. The Commission does this by removing unnecessary burdens and adapt existing legislation without compromising on policy objectives. This is what was done just some years ago with the so-called EMI REFIT, or as others call it, the EMI 2.1. That was a short, contained review that did not compromise or substantially reopen key policy objectives. This was what we were expecting in relation to MiFID. Our understanding in relation to this Commission MiFID initiative, however, is that this will be something slightly different. It was realized that this MiFID review have the potential to be bigger than just a REFIT initiative. And although we don't believe that the objective is a completely overhaul of MiFID, a lot of thinking has been put in by different institutions since the MiFID implementation 2 years ago. And on top of that, as it was mentioned before, the context we are living in, post-Brexit, as we are now, the launch of a new re-energized CMU eventually led to what looks like to be a much more ambitious review. Therefore, it looks like it will be a longer consultation than on previous REFIT initiatives, and we expect that the process of finalizing a proposal and eventually agreeing on a final legislation will take longer. This was my initial remark as a way of clarification. In terms of next steps, more specifically, the European Commission has already made public on their 2020 work program that the key legislative initiative to deepening CMU will be the review of MiFID, including the establishment of EU consolidated tape, and that will be by Q3 this year. It's not a joke, but some of you may know that in Brussels jargon, third quarter 2020 may mean any time between 1st of July up to the 30th of September, or indeed beyond the 30th of September, which in the latter case, likely to happen, should not be perceived as if the process went wrong or something of that nature, but rather as a normal development of an initiative that is complex and important, and that it's critical that the Commission get it right. As I said, this happens frequently in Brussels and should not come as a surprise to members. Before that critical step materializes, however, a few intermediate steps to take note. Members already know that the deadline to respond to the European Commission consultation is the 20th of April. Between that and the formal publication of the Commission proposal, a few things will need to happen. Most importantly, we hope different colleagues at DG FISMA will be reviewing and reflecting on the many responses to the consultation. This is a critical moment that may clearly influence the scope of the Commission proposals. And besides AFME response on behalf of the entire membership, I think we need to strongly encourage members to also respond individually to the issues that they care about the most. I should recall everyone that besides the establishment of a EU consolidated tape, that is a political commitment from the Commission, it looks that everything else is in play, including, to be fair, including the exact scope and structure of the tape, by the way. So it is therefore very important that members individually express their own views on this consultation. The next step, once the scope of legislative initiative is determined at the level of DG FISMA and at the level of the Vice President Dombrovskis' cabinet, and the draft is finalized, there is a requirement for what is called the inter-service consultation amongst the Commission services. This is still internal to the Commission, And it's a procedure used to requesting and obtaining the formal opinion of other DGs with a legitimate interest in the proposal, which normally may well take up to 30 days. This may include consulting divisions coordinating the Brexit negotiations at the Commission, for instance, or DG Growth for the topics that relate to SMEs, as an example, or indeed DG ECFIN for a broader financial markets perspective. This has already happened regarding the consultation paper itself, and members would appreciate it may bring last-minute changes to the final Commission proposal. It's also the moment where other commissioners from other countries, and the reference to other countries is important, because although commissions are not representing countries necessarily, they do carry somehow the interest of the countries they're coming from. This will be the moment, as I was saying, where other commissions will have the first opportunity to express a view, even if the areas they oversee are not directly impacted by the proposal. Concurrently with all this, the EC will need to develop a detailed impact assessment on its own proposal. This is important because the overarching principle for European Union action is the principle of subsidiarity. This principle, which emanates from the European treaties, is a principle that authorizes intervention by the Union only when the objectives of an action cannot be sufficiently achieved by the member states, but can better be achieved at the European level. Members may have seen that the Commission have already published what they called an inception impact assessment, which is being consulted for 30 days only. The final impact assessment, however, will need to be much more detailed, and will to be an important piece of work for members also to consider on their analysis. Once this detailed impact assessment is finalized, and still before publication of the Commission proposal, there is another important step that is worth taking note of. This will be the moment where a relatively new body within the European machinery intervenes. Any European Commission legislative initiative needs to be vetted and eventually approved by the so-called Regulatory Scrutiny Board, that amongst other elements assesses whether the initiative is needed and indeed whether the Union is better placed to pursue those objectives than member states individually. This is normally the last internal step before the final proposal is brought to the attention of the College of Commissioners, which will formally approve the proposal before publication. Should say, for those more interested in the detail, the college normally meets on Wednesdays, so we'll all be very much looking forward to that third quarter Wednesday when the full pack will be officially published. This will be the process within the Commission. I will probably not spend much time on detailing the process after that, as we may organize a similar members call later this year to go through the details at that juncture. I will just say maybe a few words. I will remind everyone that formally the co-legislators at the European level are the European Parliament and the European Council. Once the Commission proposal is made public, the European Parliament will appoint a rapporteur for the file, and each political party will appoint a shadow rapporteur. This group of people, the Econ Committee as a whole, and eventually the European Parliament plenary, will need to approve a Parliament report suggesting changes to the Commission proposal. Don't expect less than 9 months to a year on this process, or even more, so it will necessarily be long. Similarly, the European Council will also need to approve a similar report with similar objectives, called the Council General Approach for the MiFID review. This will be led by the German Presidency of the Council from July this year up to the end of the year, and will be followed by the Portuguese Presidency of the Council, the Slovenian, and maybe eventually, who knows, the French Presidency of the Council to finalize the Council General Approach maybe towards end of 2021, or even early 2022. From what I just said, you should also not expect anything from the Council before a few months or a year, or even more than that. Once the Parliament and the Council reach a final position, members would already know that the differences will be ironed out by a process called the trialogues. This is where the Commission is brought again to the table, and the three institutions discuss at both the technical and the political level what a reasonable compromise should look like, agreeing the final text article by article. Eventually, at the end of this process, we will have the MiFID review finalized. As colleagues said, there are a few outstanding consultations from Asthma. Those are advices to the European Commission, feeding into the Commission statutory obligations to report to the Council and to the Parliament. They may or may not influence this major level 1 change, this Commission consultation on the MiFID review. I will probably not spend time on that, but just say a few words on the AFME plans for the review of MiFID. I will just, as I said, just update members on what our plans are. First and foremost, we'll of course be responding to the different consultations as a matter of priority. More detailed plans will or have been communicated with relevant AFME committees. You should of course liaise with your representatives on those committees as they will be leading the developing of the policies and the response. On top of that, we'll have the duty to explain to policymakers and co-legislators why we believe that the review of MiFID needs to be a review that serves the users of capital markets. And I'm thinking about issuers, I'm thinking about investors and other market participants, and a review that provides a framework that down the road works for people, as that is not only our motto, but also the Commission objectives. Everything looks, I should say, too technical and complex, but just reminding everyone that AFME's mission is indeed to advocate for deep and integrated European capital markets that serves the needs of companies and investors, supporting economic growth and benefiting society, and that is what we'll be doing. Considering the several steps that I have outlined before, this will be a long process, and a few initiatives and actions have already been considered. The relevant AFME advocacy committees will take a leading role on devising the right advocacy strategies and on deciding on AFME engagement plan for the future, which will, in my view, necessarily cover the different institutions involved in this process, as well as users of capital markets. Again, as I said before, for the development of the policy, we very strongly encourage members to liaise with their representatives in those committees. Maybe in the interest of time, I will stop there, but happy to take any questions if there are any.
Thank you. Thanks very much, Pedro and Lisa. That's very, very useful. I was interested in your discussion of, and description of the broader waterfront, the number of issues that were in, particularly in the Commission consultation. And I wonder, will each and every one of them, in your opinion, make it into the legislative proposal expected in Q 2020, or perhaps only a subset?
Well, I can start reminding what I just said. Indeed, it's an open consultation. We hope that it looks like the only element of the proposal that is already decided that will be on the final formal legislative initiative is the establishment of an European consolidated tape. All the other topics seems to be in play. From what we understand, the Commission objectives are bold and want to make the capital markets work better for end users. But it's really incumbent on us and other stakeholders indeed to provide good reasoning to why a specific proposal should not be included or why others should be included. So that's the work for the next couple of months.
I think you may have already answered this quite comprehensively, but members are wondering which of those topics and what progress might we see in terms of what will be published in the EU official journal and therefore mandatorily onshore to the UK for December the 31st, 2020, when the transition period ends.
Nothing. I think Pedro has been quite clear on that. Before the end of this year, there would need to be a miracle for something to hit the official journal.
Yeah, I would agree. Of course, we know that at the council level, and the council is just one of the important stakeholders to consider. They are one of the co-legislators. The role of Germany leading the presidency for the next 6 months, or the 6 months starting July, would be critical. But it's very, very unlikely that anything will be agreed before their mandate finished.
That in itself leads towards some interesting scenarios from 1st of January 2021. You touched upon the member states there initially, Pedro, but I was wondering if you could offer a little bit more insight into how individual member states get involved in this process.
Well, they get involved at different levels. As I said, at the council level, there's a presidency of the council, as it called. Although it's up to the member states individually to form a position in that forum. One could say that the European Parliament doesn't represent the interests of member states, but indeed we know, although MEPs are aligned along the lines of political parties, they do come from specific member states, and more often than not, they do represent the interests of each member states and stakeholders coming from different member states. And at a different level, at a more regulatory level, we know that the national competent authorities, of course, feeding into the asthma advices and otherwise, will also play a critical role in this process. So we'll all be mindful of those different stakeholders.
And you see that in practice, because, for example, one thing that we will be discussing this week with research colleagues is the Amf Paper on research, which came out a couple of weeks ago. It's not a coincidence that it's come out now. It's come out now because the debate on what the Commission proposes was about to start when they published it, and is now in full swing. And people who've read those documents will see that clearly conversations have happened, as you would expect them to happen, between the authorities, and there's a clear link between the two documents. Also, some of the colleagues on the phone will recall that last year we spent quite a lot of time responding to the German Ministry of Finance consultation on what was working well and what was not working in MiFID. Again, not a coincidence that they were consulting last year. They were preparing their positions for the fact that they will be presiding this year. And those are the formal documents and consultations, and there's plenty of informal consultations going on in member states. And of course, as Pedro was saying, each of the regulators has its own perception as to what's going well and what's not going well in their own country and in neighbouring ones. And all of that will drive the discussions.
Question from a member here around the timing of the report resulting from the European Commission review of MiFID. Will there be a public report following the April 20th deadline date?
It's unlikely that there will be a formal report as such in the form of a sort of policy statement following the responses and somehow analyzing the response itself and coming to a conclusion. What is likely to happen, as I say, is that internally a lot of time will be taken, and we hope that will be the case between the services, different DGs at the Commission will be involved, and eventually the report, what we may call the report, it will be a legislative initiative from the Commission after the entire process is finalized. That is, the public commitment is to make it public on on Q3 this year. Joking, but not that much. We know that it's likely to be maybe even beyond that, and we should not be surprised considering the importance of the topics currently being addressed by the consultation.
Thank you very much indeed. And I think that contrasts with the output from the Asthma consultation papers, which will be a report, for instance.
Yeah.
We saw last year the results of their disclosures report and the results of their consolidated tape report, which tend to be made public.
Absolutely. We didn't spend a lot of time in that in outlining the detailed process on those consultations. When we were saying that indeed there's a statutory obligation for the Commission to provide reports to the Parliament and the Council. As Elisa said, it's likely that those reports will come in batches all along the time, and towards 2021 included. The advice received by the Commission from asthma may or may not influence the Commission eventual legislative initiative, but one should not be surprised if they don't influence at all. The Commission has a political mandate, and they are exercising the mandate, whereas asthma itself, by providing advice and consulting before providing advice, consulting the public, they are just pursuing what is a statutory responsibility and to which a specific timeline was given to them.
Yes, and also the asthma reports will be important because they will be read across Europe by the other co-legislator, which Pedro mentioned in passing, but that will be very, very important from Q3 next year, and that's the Parliament. The parliamentarians often rely on the advice written by ESMA, not just as an introduction to the subject, and some of them will need an introduction to the subject because they're specialists in other areas, but also as a relatively impartial assessment of what the different options available are and what the costs and benefits of them could be. Then after that, there's a lot of political negotiation, and as Pedro was saying, there's national interests and there's the expediency and the horse trading that happens behind closed doors in the trialogues. But I wouldn't want people to leave this call thinking that we should only focus on what happens with the European Commission. We need to focus across the board on what's happening with ESMA. We need to be talking to regulators in the national capitals. We need to be talking to parliamentarians and, of course, to the different member states, as we have been doing and as AFME does every day across the board on all the other subjects that it's active on.
Thank you, and I think that feels like a sensible time to draw proceedings to a close with that excellent call to action and look forward for AFME activities in the future. I'd like to also make a call to action of my own, of the members who have dialed in here. Please do join and connect with your colleagues who are engaged with the MiFID Steering Committee for a centralised view of the MiFID activities that are going on. And as Pedro and Elisa have said, please do engage with the individual drafting groups and committees who are working on these multiple work streams at the moment. I'd like to thank members not only for dialing in, but also for their hard work and commitment to those drafting groups. I know there's a great crunch on at the moment, as we've discussed, and no small matter of half term are getting in the way, and Easter getting in the way of the responses going forward. So thank you, and please do engage. Many thanks to my colleague Pedro and the chair of the AFME MiFID Steering Committee, Elisa. And we look forward to keeping members updated, and it sounds like we have committed to a call at some point later this year to discuss potentially the legislative proposals or lack thereof as they may come out. So with that, I'll give you back some 10 minutes of your day and say thank you very much.
Thank you.
Thank you.